All right. Thank you all for joining us this afternoon. This is Fair Housing Foundations, the Fair Housing Center of Southwest Michigan's introductory training on fair housing law. Today, we're going to cover the history of fair housing, the formula for determining housing discrimination, some common causes of housing discrimination, and some best practices to avoid housing discrimination. Before we begin, I'll remind that this session is being recorded. We'll have time for questions at the end, so please, if you have them, just put them in the question box or hold on to them. And a disclaimer to begin, we here at the center are not attorneys. The information contained in this training is presented for educational purposes only, and none of it should be construed as constituting legal advice. We would also like to begin by thanking the Michigan State Housing Development Authority, or MISHDA, without whose grant, the grant from whom allows us to offer this training free of charge. A little bit about the center before we jump into things. We serve the 9 counties of Southwest Michigan: Allegan, Berry, Berrien, Branch, Calhoun, Cass, Kalamazoo, St. Joseph, and Van Buren, and the Fair Housing Center of Southwest Michigan. We work to promote integration and to eliminate housing discrimination through education, advocacy, and enforcement of the fair housing law. When we say we promote integration, we mean that in pursuing our mission, we aim to reverse the segregatory effects of societal decisions. And by eliminating discrimination, we mean that we aim to remedy the actions of individuals. And like I said, our 3 tools for this are education, advocacy, and enforcement, and that ordering is intentional. The Office of Housing and Urban Development, or HUD, estimates that annually there are 4 million occurrences of housing discrimination. Every year, only about 11,000 of those are reported. So we figure if we educate well enough, we can ideally eliminate housing discrimination before it begins. Education can also encourage people to recognize and report housing discrimination. And after that report, we can advocate on their behalf and work to secure justice through enforcement of the fair housing law. So, what is fair housing? Fair housing is the right to equitable access to housing, as well as equitable treatment in all of the services involved in the housing transaction. So that's renting, buying or selling, advertising housing, anything that affects a person's ability to live safely in a home of their choice is affected by fair housing. Now, the goal of this session is simply to give you information to help protect the members of your communities. Much of the training is designed around the tenant's perspective, but it is important that housing providers also understand the fair housing law and their responsibilities therein. You don't have to memorize everything today or leave today as fair housing experts. You can always call us at the Fair Housing Center with any questions. And one of our watch phrases is where you live affects how you live. So let's dig into it. I mentioned that there is a formula for determining whether a situation constitutes housing discrimination. It consists of 3 elements. You need to have a covered dwelling, a residence or dwelling that is covered by the fair housing law, and very nearly all residential constructions are covered by fair housing. Second, you need a protected person. Federally, there are 7 protected classes that we'll dig into a little bit more, but those classes are race, color, religion, national origin, sexual orientation and gender identity, family status, and disability status. State and local governments can add to, but never remove from these protections. And each of these protections were won over time. We'll cover that timeline here in just a moment. And finally, what also needs to be present for housing discrimination is an unlawful practice. So that's any practice in the transaction that treats differently any member of a protected class, whether through intention or effect. And we'll cover that in detail here in just a moment. But first, the first element of the formula is a covered dwelling. What are covered dwellings? You'll see here a broad but not exhaustive list. A dwelling under fair housing law is to be construed as broadly as possible. There are some limited exceptions, but all places of residence that are not strictly commercial ventures, like a hotel or a motel, are usually covered by the Fair Housing Act. Uh, like I said, all aspects of the housing transaction are covered. So not only does the Fair Housing Act prohibit kicking a person out of their rented apartment based on their nation of origin, say, but it also protects that same person from similar discrimination in the application process, in process of securing a loan, in having their home appraised. Uh, there are some edge cases in mixed use dwellings, like Airbnbs or long term hotel stays. And how the fair housing law applies to those is largely based on the presence of a primary residence. So, for example, in the case of hotels, the fair housing laws seldom apply because a guest in a hotel usually has a primary residence elsewhere. Um, if you look at sheltering unhoused people, for instance, their stay might be as short or shorter than a hotel stay. The fair housing law does apply because typically there's no other primary residence. And again, that's an edge case, but important to bring up as these things become more common. I mentioned that there are some exemptions. Um, there are limited exemptions for religious organizations, smallholder owner occupied housing, and housing designated for older persons. So yeah, in limited circumstances, the Fair Housing Act can make exemptions for housing operated by religious organizations. Those organizations are allowed to give preference to people of the same religion. If the housing is not commercial, that is, they're not charging rent, and the religion itself doesn't discriminate based on other protected classes. So, for example, if a Catholic organization has a set of housing that it owns, it can give preference, it can give rental preference to other Catholics as long as it's not stepping on those other protected classes. The Mrs. Murphy rule, as it's known, is the exemption for small holding housing owners from the fair housing laws. So federally, a residence comprising 4 or fewer units that is presently occupied by the owner or the owner's immediate family member or members, that housing is exempt from fair housing law under the Mrs. Murphy rule. Each state has a particular version of the Mrs. Murphy rule, and Michigan's mirrors the federal rule while further restricting the residence to 2 or fewer units. And now HOPA, or the Housing for Older Persons Act, designates senior housing. And that senior housing is broken into 2 categories: housing for persons 55 and older, and housing for persons 62 and older. Pardon me. So a number of different rules apply to both those types of housing. So in housing meant for persons 55 or older, 80% of units need to be occupied by at least one person who is at least 55 years old or older. The terms, regulations, and advertisements of the dwelling must clearly state the dwelling's intent to operate as senior designated housing. Uh, in addition to that, housing for persons 62 years old or older must be 100% occupied by at least one resident of that age. However, often disabled people or caretakers, employees can usually live in either class of dwelling regardless of age. And even with these limited exemption cases, it's never permissible to discriminate in the advertisement of any part of the housing transaction. So these are that covers the dwellings. Let's get into the protected classes. So you can see the 7 federal protected classes, as well as the 3 primarily relevant protected classes here in Michigan. So again, federally, that's race, color, religion, national origin, sexual orientation, and gender identity, and we'll get to that in just a moment here. Disability, family status, and then in Michigan, we add also marital status, age, and just recently, source of income. So I mentioned that the 3 Michigan laws were the most relevant, or the 3 Michigan classes were the most relevant to housing. The controlling Michigan civil rights laws list more than just age and marital status as protected classes in housing. But those extra protections are held over from usually employment law. So, for instance, weight is a protected class under Michigan employment law, but weight discrimination is seldom at issue in fair housing cases. And so these three are the ones that are most relevant. And the source of income protection was signed into law late 2024. And I just want to mention before we really get rolling here that throughout this training, I'll be using class or characteristic sometimes to refer to the protected classes. Protected class is the language of the law, but sometimes it makes less sense or is more awkward to describe someone as being the class of families with children, for instance. So for our purposes, protected class, protected characteristic. So what is meant by each of these? Of course, race includes all races. Color refers to the color of one's skin. So a darker skinned person of Indian origin has the same rights as one with lighter skin. Uh, Religion includes one's membership or lack thereof in an organized religious group, as well as one's spiritual ideas or beliefs. National origin refers to the country where a person was born, or from the country where a person's ancestors came. Sexual orientation and gender identity pertains to one's actual or perceived sexual orientation, as well as the identity, expression, or perception thereof. This includes one's relevant attitudes, preferences, beliefs, and practices of their gender, irrespective of its relation to their sex assigned at birth. Family status is the presence of one or more children under 18 in the household uh, that is in a custodial relationship with an adult. So that's a parent, step parent, an adoptive parent, a guardian, foster parent, um, a pregnant woman, or a pregnant person. Disability refers to the protected class. Disability just refers to people who have um, a an impairment that significantly affects a major life activity. We'll get to that toward the back of this training. Uh, Marital status refers to single, married, separated, engaged, widowed, divorced, and in some jurisdictions, cohabitating people. Age means individuals of any age. And source of income means that a person seeking housing cannot be turned away if part of their income comes from, for instance, SSI or Section 8 vouchers. Um, these classes are protected by specific laws, and we're going to look now at a timeline of those laws. So beginning in the top left, you have the Civil Rights Act of 1866. And then down in the bottom right, you have the source of income law recently passed here in Michigan, Senate Bill 205. So like I said, the protections afforded by fair housing were won over time. And now this timeline is by no means comprehensive, but it should provide a snapshot of the moments wherein protected classes with respect to housing were enshrined into law. So shortly after the end of the Civil War and the ratification of Amendments 13 and 14, newly freed slaves and native-born Black Americans were finally recognized as citizens. The Civil Rights Act of 1866 was meant to detail primarily the economic and property rights of these new citizens, and it included explicit protections against abridging those rights on the basis of race or color. Now, of course, that law didn't eliminate all race or color-based injustice. And the next 100 years would see various laws passed, various Supreme Court decisions made that kept the project of securing the civil rights of the nation's newest citizens at the forefront of political activism. Many strides were made by these activists in the civil rights movement, especially of the mid 20th century. But despite that, race-based housing patterns did persist. So, for instance, while Black and Hispanic members of the U.S. military were fighting and dying in Vietnam, their families at home often struggled to rent or purchase housing in residential areas because of their race, color, religion, or national origin. Uh, Following pressure from organizations such as the NAACP and the GI Forum, as well as the intense pressure generated by the assassination of Martin Luther King Jr. and the subsequent riots in more than 100 US cities, President Lyndon Baines Johnson was able to accomplish the passage of the Civil Rights Act of 1968. Title 8 of the Civil Rights Act of 1968 is what we now affectionately refer to as the Fair Housing Act. And that act established race, color, national origin, and religion as protected classes in housing transactions. The Fair Housing Act would be amended further, first in 1974 to add sex as a protected class, and then again in 1988 to add family and disability status as protected classes. In 2021, Executive Order 13988 was signed, and that elaborated on the protected class of sex to explicitly include all sexual orientations and gender identities as protected class. Previously, the laws have pointed to sex and gender, LGBT, LGBTQIA+, but because of the language of that executive order, uh, I'll be using sexual orientation and gender identity as a general term to include the varied peoples who comprise this protected class. Alongside the federal fair housing laws, state and local governments have passed their own fair housing laws. And as a reminder, those laws can only expand but never curtail the protections afforded by federal law. And so the Elliott Larson Civil Rights Act here in Michigan adds marital status age protections in 1975. Later, the ELCRA, Elliott Larson Civil Rights Act, Elliott Larson Civil Rights Act, was amended in 2023 to mirror the language of Executive Order 139. And then finally, this latest one, on December 30th, 2024, Michigan Governor Gretchen Whitmer signed into law Senate Bill 205 of the 102nd Legislature, which added fair housing protections based on source of income. We do have some even more recent changes. As of January 20th, 2025, it has been declared that protections of Executive Order 13988 will be curtailed. We'll work to provide more information on this and other changes during future trainings. Another recent change is that source of income law. By adding source of income protections, a landlord cannot discriminate if a tenant's income includes Section 8 housing choice vouchers, public assistance, veterans benefits, Social Security, supplemental security income, or other retirement programs. 18 other states have laws that bar landlords from rejecting tenants solely because of their housing vouchers. Additionally, 16 Michigan cities have previously adopted ordinances around source of income discrimination. Now it is statewide here in Michigan. The legislation also defines source of income within Michigan's Elliott Larson Civil Rights Act, meaning renters are allowed to sue if they believe landlords are denying them housing over their source of income. Tenants can also file complaints with the Michigan Department of Civil Rights. Discrimination takes a number of forms, but usually it falls into one of these four flavors. There's discriminatory intent, disparate impact, retaliation, and failure to accommodate. So only behavior that involves one or more of the protected classes is illegal under the Fair Housing Act. So for example, a landlord who refuses to rent an apartment to a prospective tenant has not thereby violated the act, has not in that moment violated the act, even though a covered practice and a covered property may be involved. They haven't violated the act unless it can also be shown that the landlord's action was based on race, color, religion, sexual orientation or gender identity, disability, family status, or national origin. If the landlord's action was based on a different factor, such as a prospect's bad credit, no violation of the act has occurred. However, and crucially, the landlord in the example does not need to have been acting maliciously or otherwise with discriminatory intent, that is, active mistreatment of a person based on their protected class. The practice is prohibited even if it has a disparate impact, which is to say that a practice can appear neutral, but because of how protected classes intersect with reality, the practice could have a disparate impact. So as an example, let's say a property developer wants to build affordable housing specifically intended for occupation by nurses. Career is not a protected class, so far we're above board, and the move could even be considered noble given the profession. However, in this developer's area, 95% of nurses are white. So by attempting to limit access to the dwelling only to the area's nurses, the developer has unintentionally limited access based on race, which creates a disparate impact. Retaliation is any negative action after a person asserts their fair housing rights, and it's always out of bounds. So even when a complaint would not itself have constituted an example of illegal housing discrimination, a retaliatory action like raising the rent or withholding maintenance, that retaliation is certain a violation of the Fair Housing Act. And finally, failure to accommodate is a housing provider's failure to allow reasonable accommodations or modifications that better allow a disabled person to exercise their right to full use and enjoyment of a dwelling. It's one of the most common practices cited in fair housing complaints, and we'll go into more detail about that later. We're going to look now at different discriminatory housing practices commonly seen in fair housing cases that include at least one of these forms of discrimination. So, if a housing seeker, whether it's a renter or a buyer, um, if that seeker has demonstrated that they have the financial means to afford the housing, a bona fide offer, if they're refused the sale based on a protected class, this is discrimination. Having a certain rental rate for families, a different rate for disabled persons, different rates for members of different races, I think it's pretty plainly seen as textbook discrimination for the same unit. If a Norwegian applicant, say, is subjected to a different set of application materials, a different application form, or a more rigorous background and credit check uh, than a person of a different national origin, that would be discrimination based on national origin. So discrimination in terms and conditions mirrors that last example, offering different rental application sheets based on a person's protected class. It's unlawful to offer or impose different terms and conditions based on a protected class. So even when those terms and conditions may be seen by the person offering or imposing them as being beneficial, the different treatment is in itself discriminatory. So an easily imagined type of discrimination in this regard is using different rental rates along the protected classes. So let's say a landlord wants to charge more rent to a person who has a disability, such that they can offset anticipated reasonable modification costs. That's discrimination. A more common form of discrimination is limiting a tenant's access to maintenance, for instance. And that can be either by ignoring requests, outright denial of service, even asymmetrical standard of work can be construed as terms and conditions discrimination based on a protected class. So, like we said, discrimination doesn't need to occur while a tenant is living in a house or apartment. The fair housing law applies to all aspects of the housing transaction, and offering different information in any of these transactions, um, as long as it's offered differently based on one's membership in a protected class, is discriminatory. Um, so one that we will see sometimes is an apartment manager wants to limit use of the pool to adults only or have adult swim hours. This is discrimination based on family status. So something even so simple as a sign at the pool that says children must be accompanied by adults can be construed as discriminatory on family status grounds. Uh, again, this is ostensibly a positive effort. The pool's dangerous. Kids are usually at a higher risk of danger. It's nevertheless discriminatory based on family status. So a best practice there would be to consider instead the neutral phrase, no lifeguard on duty, swimming at risk. This phrase doesn't single out residents with families or assert that only children are at risk. So one that does show up is this type of quid pro quo sexual harassment. It's a violation of fair housing law in addition to a number of other laws, but this would usually fall under the protected class of sexual orientation and gender identity. It also runs afoul of the Violence Against Women Act, or VAWA, which offers certain housing protections and rights in such cases. And despite the name of the act, its protections do apply to all survivors of intimate violence, regardless of their gender expression or identity. Move now into steering. Steering is any practice that leads to or perpetuates segregation along the protected classes. Steering describes a wide range of behavior from massive neighborhood-sized plans of segregation, which were more common earlier in the 20th century, to smaller micro-segregation actions, like putting all families with children in the rear of the complex near a playground. Again, steering need not be undertaken maliciously, but if there is a disparate intent or impact, it could be steering and is therefore prohibited by the Fair Housing Act. So again, just in bullet points, steering is assigning any person to a particular section of a community or neighborhood employing codes or other devices to segregate or reject applicants, denying or delaying the processing of an application or refusing to approve such an application uh, in an apartment, a cooperative, a condominium, a dormitory. These are all steering. Um, One form that steering can take is exaggerating either positively or negatively the characteristics of a neighborhood. So, for instance, if you're showing a prospective buyer who has Spanish as their first language, if you're showing them only the available homes that are close to a church that holds Spanish language services, for instance, um, the realtor or otherwise agent might see that as an attempt to be kind to this person and their needs. It's nevertheless steering. So, to reiterate, steering is any behavior that limits a person's ability to freely choose their own housing. So, like the Spanish church example, playing up or down the characteristics of a neighborhood based on an assumption of what a prospective tenant might want, uh, that's steering. So, fair housing, while it does aim to secure justice in housing, also has as a central tenet that a housing seeker knows better than anyone else their own housing needs. It's never a housing provider or realtor or agent's place to make that call for the seeker. Misrepresenting availability can be seen as another version of steering. So, not showing all available housing has, in essence, the same effect of pushing families with children to, the playground adjacent area of the apartment complex. Uh, it bears repeating that fair housing aims to give full freedom of choice to housing seekers in all aspects of the housing transaction. I mentioned that disability is the most common cited protected class in fair housing complaints. Uh, that's been true for a number of years now. And disability under fair housing law is any physical or mental impairment which substantially limits one or more of a person's major life activities. It also covers a record of having such an impairment or being regarded as having such an impairment. So, a major life activity should be broadly construed. That's any impairment which limits or substantially changes by, say, requiring the use of a wheelchair or white cane. Uh, it's any impairment that limits or changes those major life activities can be considered a disability. Disabilities are sometimes apparent, but they are quite often non apparent. And under fair housing law, all people have the right to full use and enjoyment of their home. So sometimes a person's disability may require that changes to either the rules of a housing arrangement or the physical space of a dwelling uh, be carried out to achieve that. And that apparent non apparent split is important to the process one may have to go through to secure those changes. And we'll talk about that here in just a moment. So remember that discrimination can be present with or without intent. Um, Disparate impact is sufficient. The the apparent, excuse me, rather, the definitions of disability under the Fair Housing Act are analogous. A disability does not need to actually be present for discrimination pertinent to disability to exist. So that's why the Fair Housing Law covers people who are actively living with the disability, people who have a history of having lived with the disability, people who are regarded as having such a disability, and the people with whom they interact are also. So one of those forms of discrimination is failure to accommodate. So that's a refusal to make accommodations of rules, policies, practices, or services. When such accommodations may be necessary to afford such a person an equal opportunity to use and enjoy a dwelling, uh, or refusal to permit modifications that allow the same. As of March 13th, 1991, new multifamily dwellings have all needed to be constructed with accessibility in mind. Now, these accommodations and modifications exist because, of course, not all new construction is multifamily, and not every dwelling occupied by a disabled person is a post 1991 construction. So, accessibility then is accomplished through those reasonable accommodations, which again are changes to rules, and those reasonable modifications, which are changes to a space. Refusing to allow those accommodations or modifications is a violation of the Fair Housing Law. So as we've covered, individuals with a disability are entitled to the full use and enjoyment of a dwelling, and those changes may be necessary to achieve that. So we're going to talk now about accommodations, then we'll talk about modifications, and finally, we'll briefly talk about what constitutes reasonability. So a reasonable accommodation, much like how disability is defined under the law, should be construed broadly. What's needed and how it is provided depends on the circumstances of the person who needs it. And crucially, it is the duty of the person with that disability to request the accommodation. Once again, they know their needs best. And the idea here is to assist a tenant to achieve full use and enjoyment of the dwelling, but at the same time, we don't want to place an undue burden on the housing provider. Why are reasonable accommodations required? Again, they may be necessary to afford a person with disability equal opportunity to use and enjoy a dwelling and the associated common areas. These common areas include community rooms, swimming pool, laundry room, exercise room, garden. Of course, this is not an exhaustive list. People with disabilities are not obligated to reveal their condition. Recall that the distinction between apparent and non-apparent disabilities. It's unfortunate, but it is often true that non-apparent disabilities can be treated with more suspicion by housing providers. So, for instance, the need for a wheelchair is easier to prove to an outside observer than the need for an animal that helps someone manage their post-traumatic stress disorder, for example. Reasonable accommodations then are needed when the person with a disability asks for them. The reasonable accommodation helps them achieve full use and enjoyment of the dwelling, and the reasonable accommodation does not constitute an undue burden on the housing provider. There's no standard catalog of accommodation. People have unique needs. But for that reason, it's the responsibility of a housing provider to listen to reasonable accommodation and modification requests in good faith and to not assume what a person may or may not do. So here we just have a list of examples of some of the more common accommodations we see in fair housing. It might be appropriate to permit a tenant with a mobility impairment to mail in a rental payment rather than pay in person. In cases where a rental agreement doesn't allow overnight guests, it's reasonable to permit tenants with disabilities to have a 24-hour personal care assistant who lives with them if they need that care assistant. In most but not all places, that caregiver is not beholden to rent requirements as they're not a tenant but a worker. Sometimes the number of accessible parking spots as defined by the Americans with Disabilities Act or ADA, sometimes that number of spots may be insufficient for every tenant who could benefit. A reserved parking spot, usually one that lessens the distance or obstacles between the spot and their dwelling, can help. Some people with disabilities may have little or no rental history because they've previously lived with, for instance, relatives or in a medical situation or an otherwise non-standard rental agreement. It might be appropriate then for a housing provider to accept references in lieu of a rental history. Even if there's a no pets policy, a disabled tenant must be allowed to keep a service or companion animal if they can provide proof of that need. We're going to get into that here. Note on language. The Americans with Disability Act defines a service animal, and the Fair Housing Act talks about service, support, and companion animals variously. So again, we refer to the animals that help a person with symptoms of their disability as a service, support, or companion animal. Because a person's disability does not exist only within the home, it's useful to maintain these distinctions while remembering that the fair housing laws do not distinguish them. The Americans with Disabilities Act maintains a separate definition for service animals, such as a seeing eye or leading dog for the visually impaired. And that is to protect that animal's use in public spaces. The Fair Housing Act, because it applies to one's own home, the distinction is less relevant It should be remembered, however, that the care that can be provided by an emotional support animal is no less important or relevant than that provided by a service animal. So a service dog, as we mentioned, can act as a leader for the visually impaired. They can also act as stability aids. They can open doors, fetch medicine, or even in some cases, smell and alert to oncoming seizures. Of course, that list is by no means exhaustive. ESAs, or emotional support animals, will often serve less apparent but no less important functions, such as reducing stress during an anxiety attack, distracting from or halting self destructive behaviors, comforting during PTSD or otherwise anxiety episodes. That list also goes on. Um, but that said, one of the most common reasonable accommodations that arises in fair housing is service support or companion animal related. So when a tenant indicates a need for a service animal, a housing provider can, especially in the case of a non-apparent disability, request that the tenant provide a letter from a healthcare provider. That letter verifying that the tenant has a disability which requires the presence of the animal to ameliorate um, that disability or the symptoms thereof. Courts have ruled time and again that licensing or certification of service animals is not required, so long as the tenant can demonstrate that the animal does provide necessary assistance. Importantly here, a housing provider cannot inquire specifically about the disability the person has or the services that the animal provides. Uh, while many support animals are dogs, they can be any type of animal. They don't need to wear any special harness or tag. They don't need to have any special certification or licensing. And in a few cases, an individual with a disability may require more than one support animal. All that's required in those cases is that there be a nexus of care, uh, is that the nexus of care can be established between the animal and the disability, which is to say that the animal provides some function that alleviates the symptoms of the disability. Uh, Support animals are a reasonable accommodation in that the housing provider accommodates the tenant by waiving their no pets policy to allow the presence of the animal or animals in the home. However, sometimes what is needed is not an accommodation, but a modification. And these are alterations to the physical space that may assist a tenant in navigating that space, such as grab bars to help with stability, usually in slippery surfaces like a shower, or ramps to allow wheeled travel. Uh, Sometimes also the modifications are necessary to help a person be alerted to changing information in their home. So one that we'll see is flashing lights instead of a doorbell for a hearing impaired person. Um, of course, much as is the case with reasonable accommodations, the list is not exhaustive and it is up to the person with an impairment to determine what modifications suit their needs. Other examples of modifications include widened doorways, a zero-step shower instead of a high bathtub wall, reinforcements to the studs of a wall for the installation of a grab bar. Again, by no means exhaustive. Excuse me. It's usually quite inexpensive or even free to make a reasonable accommodation or an adjustment to the rules and regulations of a housing situation. But if you're going to install a ramp, for instance, that requires time, labor, and materials, and those all have costs, and those costs can add up. So where does the money come from? Generally, a tenant is expected to cover the expenses of making reasonable modifications, unless those modifications also benefit the whole building. So, for example, building a ramp to a pool but benefits the whole building, uh, and that cost then goes to the housing provider. But while changing the rules to allow a reserved parking spot should cost nothing, printing and installing the sign that designates that spot uh, does have a cost, and the tenant may be required to cover those costs. The above pertains to private housing, but in the case of subsidized housing, such as Section 8 or Rural 515 programs that receive federal money, the housing provider is required to cover those costs. So, of course, there are some things that pop up with reasonable modifications. So, for instance, to save money on the cost of a modification, a tenant may offer to accomplish that modification themselves. A housing provider does have the right instead to insist that a professional install the modification. This is what's known as the work being done in a workmanlike fashion. Wear and tear is defined as expected deterioration that occurs over time, and that's a fancy way of saying that it's defined on a case by case basis. And a neutral change uh, refers to changes that do not impact any later tenant's ability to fully use and enjoy a dwelling. So, for instance, a doorway that is widened for wheelchair use does not then need to be narrowed at the end of the tenancy of the person who requested the modification because it doesn't impact any future tenant's ability to use that space. A grab bar in the shower, on the other hand, may be required to be removed, but if the wall had to be reinforced so that the grab bar could be installed, that reinforcement does not need to be. So, what constitutes reasonability? A change is not reasonable if it imposes an undue burden or a fundamental alteration of the provision. So sometimes the requests, in the case of an undue burden, that means that in the context of the housing provider's total financial and administrative costs, the accommodation is too unwieldy. Uh, when a request can constitute a fundamental alteration, when the accommodation requested would cause the housing provider to change the way they do business, or where what's requested goes beyond what is normally provided. So, for example, an unreasonable accommodation may be that a tenant with a chemical sensitivity disorder, let's say this tenant requests that the owner surveys all tenants in the building to determine the time of day and the chemicals they will use to clean their apartment. Uh, they then ask that the owner compile this information for them on a weekly basis so that they can plan to be away from their unit at the time certain chemicals are used. This obviously, I think, constitutes an undue administrative burden. Uh, an unreasonable modification could be requesting the installation of a chair lift when a ramp would suffice. A mechanized lift is, of course, often far more expensive than a simple ramp. A fundamental alteration of the provision of housing could be seen, for example, in a senior designated housing or housing constructed under the Housing for Older Persons Act dwelling, where a tenant requests that their several grandchildren live with them. This invalidates the terms of the program in that it is housing intended for older persons. In all cases, however, where an accommodation or modification is deemed by the housing provider to be unreasonable, the housing provider does have a duty and a responsibility to work with the tenant to try to find a more reasonable solution. While not specifically protected under the Fair Housing Act, there is a tricky issue sometimes when determining housing for people who have criminal records. So, nearly 100 million US adults have a criminal background. When these people re enter society, what can they expect when trying to secure housing? Like I said, having a criminal record is not yet a protected characteristic, but it can and does intersect with other protected characteristics. So, for that reason, certain approaches to criminal background screening in a tenant application process can present a disparate impact disallowed by the Fair Housing Law. There are, of course, best practices for this process. So, a housing provider, when dealing with a tenant who has a criminal record, should do case by case reviews. They should give the applicant a chance to explain the record. They should work to remain mindful and to avoid their own biases, and they should run Fair Credit Reporting Act or FCRA compliant background checks. So when we say case by case reviews, we mean that as an initial matter, blanket policies that automatically reject prospective tenants with a felony conviction, other than drug offenses, should be avoided. Instead, those policies should be replaced with a policy that reviews individual criminal histories on a case by case basis. These reviews should examine the severity of a charge, the length of time since the conviction, and the possibility of risk to others presented by a person with a background. Landlords should give the applicant a chance to explain. So, when providing an applicant a chance to explain any offense and consider those explanations as part of their determination, including taking into account how long ago the conviction occurred, what it was for, and any evidence of rehabilitation. When we say remain mindful and avoid biases, a landlord must also remain mindful to avoid treating individuals with the same or similar criminal background differently based on sex, race, color, national origin, even if they had no discriminatory intent. As the process can be time consuming, you may want to wait to the end of the application process to evaluate an applicant's criminal history. And then finally, the Fair Credit Reporting Act. There's a lot to get into, but running FCR compliant background checks is always a good move. So certain states, like here in Michigan, have clean slate laws that allow the expungement of old records. And those should be taken into account as well. Now, of course, there are exceptions, and those exceptions exist where landlords may continue to automatically reject leasing applicants if they've been convicted of the manufacture or distribution, not simply possession or use of illegal drugs, or if the tenant has been charged with crimes of dishonesty. So these are things that include, but are not limited to, fraud, embezzlement, forgery. These crimes are specifically noted by the Fair Housing Act as constituting an exception. Last but not least, as far as housing goes, we're going to talk about occupancy standards. Like criminal records, there's no specific fair housing laws that apply to occupancy standards, but those occupancy standards do occasionally intersect with protected classes. So the rate at which families live in multi-generational homes, for instance, can often follow the protected class of national origin, for instance. So there's just a guideline from HUD that 2 persons plus 1 per bedroom is reasonable. So if the house has 3 bedrooms, that's 2 per bedroom is 6 plus 1. 7 would be an acceptable occupancy standard for that dwelling. Relatedly, a landlord doesn't have the right to determine who may room with whom. There is an exemption there, and that is in cases where a tenant has a criminal record that includes a sexual offense, then assigning those rooms is protected under fair housing law. So there are other things to be mindful when it comes to occupancy standards. There's overall size of the unit, there's a configuration of a dwelling, septic capacity, so the overall size of a unit. If, say, you have a tenant who's like 7 feet tall and the room has 8-foot ceilings, you may not want to consider that a bedroom, and therefore the occupancy standard guideline changes. But these are all determined by local and state ordinances, and so check with your fair housing center if you have more questions about occupancy standards. So, as we've covered, there's a lot to fair housing law. So how best to avoid breaking the fair housing law. In brief, you want to treat people equally, you don't want to make assumptions, and you want to be open and honest at all times during the transaction. So during tenant application and screening, you should treat all applicants fairly. You should follow the same screening processes for every applicant. You should never misrepresent availability, and you should tell applicants about all available units. And that's what a tenant should be able to expect when applying for an apartment. If you as a tenant or a friend of a tenant or advocate of a tenant see that a person isn't being treated fairly or are turned away from housing for what they believe is an illegal reason under the fair housing law, you should contact the Fair Housing Center or another enforcement agency immediately. Those enforcement agencies here in Michigan are the Michigan Department of Civil Rights and the Office of Housing and Urban Development. So finally, a fair housing adherent provider will treat everyone the same. They will allow housing seekers to make their own choices, and they will make decisions based on an applicant's behaviors and not that applicant's characteristics. That brings us to the conclusion of our presentation. Here's just a truncated list of some good resources. The HUD website, you can crawl around it for hours and learn quite a lot about the Fair Housing Law as your curiosity dictates. The Fair Housing Act as amended, effective March 12, 1989, is a good legal document for the last major change to the law. HUD Regulation 24 is a good resource. the Elliott Larson Civil Rights Act here in Michigan, and the websites Justia and Legal Momentum have good discussions on the law and related jurisprudence to the Fair Housing Law. So with that, I would like to thank you for joining us today, and I will open it up for questions after we stop recording.